All right, good evening, everybody. Thank you very much for joining us online. I'd like to just start by acknowledging the traditional owners of the land that, although we're not meeting on, I'm certainly present on tonight, and that's the Yagara and Turrbal people, and acknowledge their elders past, present, and emerging. So my talk for tonight is Queensland's Human Rights Act and climate change litigation. So I think the blurb for tonight's event mentioned the right to a healthy environment. So something that I will touch on a little bit later is that even though we do have a Human Rights Act now, we don't have an enshrined right to a healthy environment, which I think is okay for what I'm looking at, which is climate change litigation. I think it means that lawyers will just need to be a little bit more flexible. So what I'll be talking about tonight is mainly the right to life, which is one of the enshrined rights, but I'll get to that a little bit later. So my talk tonight draws fairly heavily on a recently published paper that I co-wrote with Brianna Collins, who some of you might know. Bree's a final year student here at UQ, who did her summer research scholarship with me last summer about the time when the final debates for the Human Rights Act the Human Rights Bill rather, were happening. And yeah, Bree and I have done quite a bit of work together leading on from that. And we wrote an article looking at, in particular, the right to life and how that could be used as a vehicle for climate change litigation in Queensland. So the first part of my talk tonight, before I get into looking at the Human Rights Act, I wanted to talk about climate change litigation more generally, because there will be a lot of you that haven't really engaged with the subject matter of it before. So climate change litigation has been a legal tool that has been used by concerned citizens and environmental groups globally for the past 2 decades or thereabouts. And climate change litigation is a really useful tool in circumstances where government action on climate change has been either absent or weak. And in this sense, climate change litigation fills a regulatory gap. So where citizens are unhappy with government action or inaction, as the case may be in the climate change space, they can bring proceedings before a court. And I heard somebody talk about this a few months ago, and he talked about the fact that the doors of a court are always open. So you always have that right to go to a court and air your issues to an extent, whereas you can't push through legislation in the same way. So climate change litigation is really useful in that respect. So what cause of action does climate change litigation take? In a nutshell, many, basically. So in most jurisdictions, you won't have an explicit statutory right to bring an action on climate change grounds. So for this reason, litigants have had to find existing causes of action that exist in their jurisdiction and try and use these existing areas of law to frame climate change arguments. So there's a fair bit of creativity involved in that respect. So the diagram on this slide is from a book by Jackie Peel from University of Melbourne and Harry Osofsky, who's an American scholar. And they've done a lot of the really leading work on climate change litigation. And they define climate change litigation really broadly and use this concentric circle approach. So under their approach, litigation might have climate change as a central issue or a peripheral issue. It might just be a motivation for bringing the litigation, or it might not even be framed as related to climate change, but will have implications for it. So this really gives you an idea of how broad the net can be cast. There's so many different causes of action you can use. And this is a flowchart from the United States. So this was put together by the Sabin Center for Climate Change Law at Columbia University. And they have this just fabulous database where they track all climate change litigation globally. And you can see here from the slide just a bit of a snapshot of the breadth of actions that climate change litigation has spanned in the United States context. And you probably can't see on your little computer screens, unfortunately, the little grayed out bits underneath that counts the number of cases, but we're talking about an awful lot of cases. So I think most of them have been in the top section. So under NEPA, there's been over 200 cases. Their Endangered Species Act has been 118. There's been a lot under state impact assessment laws, almost 200, and that's certainly our experience in Australia as well. But what it shows you just from this snapshot is that there's a huge range of areas of law that can be utilised for climate change purposes. And the United States, probably unsurprisingly, has really led the world in terms of the volume of climate change litigation. But Australia is actually number 2 after the United States in terms of number of climate change cases that we've had. And some data from about a year ago now ranked Australia as the second and said that we'd had 94 climate change related cases decided in Australia. So depending on how they define it, we've probably gone over 100 by now, I would say. So the vast majority of climate change litigation in Australia to date has involved administrative challenges to government decisions to approve emissions intensive projects, which are generally large coal mines. So that's why I've circled that bit in green. What the cause of action will be would depend on the subject matter, the jurisdiction in question and what their legislation provides for, but generally it would be judicial or merits review challenges to environmental approvals. Everything else on this slide are more the sectors where I see that there's likely to be action in the climate change litigation space in coming years. And this is by no means comprehensive. This is just my little guide to the world of what I think is likely to be a big issue in coming years. So the second box here is operators of emissions intensive industries. So these are the actual companies running the coal mining operation or running the electricity generation operation. So currently litigants have taken the strategy of going after governments because there are those very clear routes to challenge a decision under general environmental laws, not specifically on climate change grounds, but under environmental laws. But as this gets harder to do, if it gets harder to do, I should say, then I think litigants might look for actions against the operators themselves. And Chris McGrath, who's a barrister here in Brisbane, who does a lot of the pro bono work, he's hypothesised that perhaps you could get a group of citizens from a country like Papua New Guinea, where they're already experiencing some pretty severe climate change impacts, and they could mount a claim against, for example, the largest emitter in Australia, so one of the big conglomerates that operates a few different power stations. All sorts of ins and outs about that you can see on Chris's website, but I suspect that that is somewhere where we might see some action in coming years. Local government planning decisions, I think in contexts where, for example, properties are affected by hazards like sea level rise and bushfire, there's a very high potential for negligence proceedings. And I've written a lot about this, particularly in the sea level rise context. And I think that's something that will really heat up over the coming decades as these impacts materialise much more strongly. And similarly, the next box there mentions adjacent property owners. So for example, if somebody constructs a seawall to protect their property, but it in fact exacerbates erosion to neighbouring landholders, you could see an action in nuisance. The two boxes at the end there, the corporate law space and human rights, are where I think we're going to see most action in the immediate future. So corporate law, I'm only going to touch on very briefly, but it's really heating up in that space. There was something released in 2016 called the Hutley Opinion. So Noel Hutley SC is a leading corporate law barrister, and he was briefed by Minter Ellison to give an opinion on whether he thought that there were obligations under the Corporations Act for companies to consider climate risk. And he concluded there probably were. He provided an updated opinion in 2009 where he was fairly equivocal that the duty of due care and diligence under the Corporations Act would extend to considering climate change. So pretty firm in his language there. So I think that will be a real space to watch in the coming years. We're also in the early days of seeing shareholder actions against banks for failing to disclose climate risks. There was a case against CBA, and there's also a case on foot against a super fund for breaching fiduciary duties for failing to consider climate change. So as I said, we're not talking about corporate law tonight, but just to contextualize, I think that's a real space to watch. As I said as well, this isn't comprehensive. I think different people would characterize this in different ways, and you could certainly add something depending on our concentric circle approach, like all of the criminal actions currently on foot against climate protesters. That could be something to add to this chart. But there's certainly a lot happening in this space, even in Australia, which is what I wanted to touch on there. So what I would like to do now is just continue going on for a bit longer with climate change litigation generally, because what we're going to talk about a little bit later in terms of the Human Rights Act is really going to build on the momentum that we've had to date in other spaces. So there have been several very major climate change cases in Queensland over the past decade. I've listed the trial judgments for those three cases here. And the second one in particular followed a fairly complicated appellate route. And I'm not going to worry about that. I'm just looking at the first instance decisions. So these three cases were all land court cases, and they all took the form of objections to decisions to approve coal mines in Queensland. And approving mines in Queensland, in a nutshell, you need to get a number of different approvals to construct and operate a coal mine, including a mining lease under the Mineral Resources Act and an environmental authority under the Environmental Protection Act. And those statutory schemes require decision makers to take into account certain factors in deciding whether or not to provide these approvals. And that includes environmental factors. They're not explicitly required to consider climate change or greenhouse gas emissions, but they are required to consider various environmental factors. So litigants have argued that these requirements to consider these various environmental matters effectively imply an obligation to consider climate change impacts. So going back to what I said before, we don't have explicit causes of action, so it's having to build on the momentum that we've already got in other areas of law. So the object of climate change litigation would depend on the proceedings that you've got. The Queensland regime's a little bit unusual compared to other jurisdictions in that the court makes it's not a decision, it's a recommendation before the final decision is made on the environmental approvals. So effectively, there's an impact assessment process whereby interested parties can make objections to a project, and the decision makers then indicate whether or not they're probably going to approve the project. And at that point, the persons that have made objections can ask that their objections be heard by the land court effectively. So the land court conducts a trial and then makes a recommendation. Then the decision maker makes their final decision, and they have to have regard to that recommendation. So it's a slightly unusual process, which is why I thought I'd just highlight that. So the object in these sorts of proceedings is to, I suppose, get the court to recommend to the minister making the decision that the project be refused. That would be the outcome that they're looking for. Now, these three cases have been unsuccessful. The middle one, there was this very odd kind of maybe yes, maybe no decision made by the land court, which I think could have perhaps just been a nod to the fact that the minister still gets to make their own decision anyway. But that, as I said, went on a very complicated appellate route. And I think we can just say that they've been technically unsuccessful. And there have been several, I guess, probably obvious barriers to success in these cases. And one of them is that they're challenging mines. So a mine is the digging up of the coal and the exporting it overseas. Sorry, exporting it in these cases, and overseas is the target market for certainly all of these mines. And the issue with that from a climate change perspective is that the digging up of coal doesn't actually contribute much by way of greenhouse gas emissions. It's the burning of the coal that contributes 99% of the emissions from a particular project. So you need to then make the mining company who are digging up the coal effectively responsible for the actions of a third party who may or may not be overseas in order to really make the emissions associated with the project significant enough for the court to be interested. So that's been one of the really big hurdles. Now, as I said, they've been technically unsuccessful, but I think a lot has happened through the process of these three cases. And this is a summary of the points that we made in an article I wrote a few years ago with Sean Ryan, Sean's I'm not sure what he's called now since EDO nationalised, but certainly at the time he was the principal solicitor of EDO Queensland, and he's basically run all of this litigation. So Sean and I wrote an article where we went through and looked at the successes that had come through those three cases. Sean was a bit, I think, frustrated at the fact that at the time there'd been a bit of media about the EDO or abusing process for, bringing these repeated unsuccessful claims before the court. But what we tried to show is that actually a lot of things had happened through this process of litigation. And, often it does take a few cases or a dozen cases or several decades of cases before you get that win. And a parallel is often drawn between climate change litigation and the tobacco litigation in the United States, where it took decades to get success. So we thought we'd just outline what had happened, and we identified the fact that climate change is now accepted and uncontroversial in the land court, as it well should be, but the predecessor to the land court quite famously rejected climate science in about 2005. So that was an important development. Scope 3 emissions are legally relevant for the decision maker to consider. So those Scope 3 emissions are the third party burning of the coal. So our land court now says those emissions are legally relevant, which I think is a really big step to consider, given it accounts for 99% potentially of emissions. They've acknowledged that cause and effect between a project's Scope 3 emissions and climate change exists, which is really important from a causation perspective, because you can't pin a particular carbon dioxide molecule that's burned with a particular impact on the climate. It's a big cumulative thing that happens up there in the atmosphere, and they've been prepared to accept that from a causation perspective. Single projects are significant, which I think ties in with that earlier point, even though it's one of a number of projects, hundreds of thousands of, potentially millions of things causing emissions. Single projects can be significant. Emissions are assessed on a cumulative basis, which is important if we're looking at projects that might run for up to 60 years. We're looking at the totality of emissions. And number 6, not really relevant to climate change litigation, but there have been some other benefits through that litigation, which is really important. So there is an awful lot that's happened just in that trio of cases, and I think it's really important to bear that in mind. The remaining hurdle to success before the Land Court, as I see it, is what is often referred to as the market substitution assumption, or more pejoratively often the drug dealer's defense, which I'll come back to later. And this really boils down to the proposition that if I don't do it, someone else will. And this is a passage from the Wandoan case. That's the first in the trilogy. And you can see how the court applies it here. So they say it's difficult to see that this project will cause an impact on the environment. And the reason why is that the applicants say that stopping the project will have a negligible impact on climate change, because other coal will be mined elsewhere, which will in turn produce the same or higher amounts of emissions when burned. So what they're saying is that if you take us offline, if you don't allow us to dig up this coal, some other hypothetical company in an unnamed country is going to develop a coal mine in its stead to substitute for this. So the savings you're getting here in Australia will be effectively offset by something bad happening elsewhere. So you're getting this net effect. And they're using that to convince the court that the project will not have an impact on the environment, which almost defies belief, I think. And this is something that I have a particular problem with. So I took Bree along with me again to write a paper on this that was just published very recently on all the different grounds on which we think that the market substitution can be debunked in climate change litigation. So one of the grounds is that it just defies economics 101, basically, which is that there's a relationship between supply and demand. I'm no economist, but it seems kind of obvious to me. The other thing that we talk a lot about is the fact that those cases, so that trilogy of cases, were all pre-Paris. And I'm not going to get into the nuts and bolts of the Paris Agreement. That's another talk for another day. But it did shift dialogue globally, certainly. And countries are doing a lot to work towards reducing their emissions in line with the pledges they've made under Paris. And it's now clear, there's been a lot of modelling done, that continuing to use coal as an energy source and meeting Paris targets are completely incompatible. So it's really hard to then rely on this, that we're going to continually have, this other source of coal continuing to dig up and have it burned by somebody because of the progress that's been made overseas. So I think it's really difficult to say that we can get that direct substitution, certainly over the timeframes that these mines exist for. I think this also raises problems with the burden of proof and from an evidentiary perspective. So if you think about civil cases, you need to prove them on the balance of probabilities, even though some slightly odd rules apply in the land court. How can you prove on the balance of probabilities that this certainty that you've got before you, mathematically quantified exactly what's going to happen, is going to be offset by this hypothetical unnamed alternative? So I think that's really problematic. And this doesn't carry much weight in the court, but I also have pretty big moral and ethical objections to the assumption. And as I said before, it's often referred to as the drug dealer's defense. And if you think about it in that context, a drug dealer doesn't get to go to court and say, well, yes, I did this, but if you take me off the streets, another drug dealer will pop up in my stead. The court doesn't care. It doesn't excuse the wrongdoing that individual has done. So anyway, that's going on a bit of a tangent, but it's something that keeps me up at night, the market substitution assumption. So I wanted to have my say there. I think the other interesting development that's happened in the last year, when I say I think conditions are building for a successful claim in Queensland, the landmark Rocky Hill case that was handed down by the New South Wales Land and Environment Court, so post-Paris, which I think is important. Slightly different scenario in that this was a challenge to a refusal of a coal mine. So a pretty different context in that respect. And there were a lot of other big considerations for the court, like amenity impacts. This was something very, very close to a town. But Chief Justice Preston upheld this refusal. He rejected the market substitution assumption, and he wrote a very long, you can see this is paragraph 699, and very robust judgment, going through these things in a lot of detail. And he made this statement that's now kind of gained infamy across the world and been referred to as the wrong place, wrong time statement. So he said an open cut coal mine would be in the wrong place, which is the amenity element of it, at the wrong time. And the coal product will increase global concentrations of greenhouse gases at a time when what is now urgently needed in order to meet targets is a rapid and deep decrease in greenhouse gas emissions. And these dire consequences should be avoided. So a really, really strong judgment. Chief Justice Preston's a pretty robust sort of guy. He's been on the court for a very long time. I think he knew that this would attract some criticism, and the media did come out swinging. They didn't quite say bias, but they got pretty close to it. But organisations like the New South Wales Bar Association came out in defence of him and said it was, there was nothing biased about the judgment. It was very above board. But I guess what you can see from that, and I'll come back to this later, is that you do need a brave judge in some of these cases to be able to make this big step. And I don't think that's something that we can underestimate. But anyway, climate change litigation in this space is just going to continue to heat up. And I really think that conditions are becoming more favourable to a successful climate change case in Queensland. And what has come before us is paving the way and really setting the foundation for that successful case. And I mentioned before tobacco litigation as an example. Success doesn't always come easily in novel litigation. It often takes a while. And certainly the Rocky Hill case wasn't out of the blue. It built on decades of New South Wales jurisprudence. So I do think we need to be a bit patient. And even though, as I'm about to say, I think the Human Rights Act offers enormous potential, it might not quite be a magic bullet straight away. So something very important and very useful that happened this year is the commencement of Queensland's Human Rights Act. So this act was passed in 2019 and it commenced on the 1st of January 2020. And it makes Queensland now the third Australian jurisdiction to have human rights legislation. So we joined Victoria and the ACT in that regard. It enshrines a number of rights which derive from international instruments like the ICCPR. And the ones that I've underlined in red here are the ones that myself and some other people doing some thinking in this space think that could have some potential for climate change related arguments. And I'm not going to talk about all of these, or we'd be here until midnight. I'm going to focus just on the right to life, because this is what I think really appealed to us as the low-hanging fruit, I suppose, in terms of which right you could use to frame a climate change argument. So that's what I'm going to do, look at how we can use the right to life in Queensland. And I'm then going to get into the machinery of the Act and talk about how the litigation would actually potentially look in practice. So there are three preliminary points that build upon each other to really set the scene as to how a human rights claim based on a violation of the right to life could proceed on climate change grounds. So the first of these three interlinking factors is that internationally, climate change is interlinked with the right to life. So the right to life under the ICCPR has been in existence for a very long time, and it has evolved over time to the point where the relationship between human rights and climate change has become a really key part of discourse of both human rights and climate change bodies. So this is an excerpt from the general comment from a 2018 general comment of the Human Rights Committee. And it makes some of the most wide-reaching and explicit comments to date on this issue. So it says the Human Rights Committee stated that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. Okay, so it's one of the biggest threats to the right to life. And it goes on to say that implementation of the obligation to respect and ensure the right to life includes measures taken by state parties to preserve the environment and protect it against harm, pollution, and climate change caused by public and private actors. Okay, so if a state is to respect the right to life, that includes measures to preserve the environment and protect it from climate change. That's pretty straight in terms of what they're saying. There've also been a lot of other cases at the national level in other jurisdictions explicitly linking the right to life and climate change. So just very briefly, some examples. The Ashgar Laghari case from Pakistan, a citizen there alleged that a failure to implement existing climate change policy offended his fundamental rights, including the right to life. And the court held that the delay in implementing this policy offends the fundamental rights of the citizen, which need to be safeguarded. And to address this deficiency, the court made several orders relevant to ensuring that implementation occurs. There's also the Future Generations case, which was a Colombian case. And there the plaintiffs alleged that the government's failure to reduce deforestation and ensure compliance with the target for net zero deforestation in the Amazon by 2020 threatens plaintiffs' fundamental rights, including a right to life. And the court held that the fundamental rights to life and health are substantially linked. And in the absence of a healthy environment, subjects of law and sentient beings in general will not be able to survive, much less protect those rights for future generations. And deterioration of the environment is a serious attack on current and future life and other fundamental rights. So some very, very strong statements there from that court. And what this shows is that there is this very clear link that has developed between human rights and climate change at that international level. So that brings me to my next point, which is that these international developments are relevant to interpreting Queensland's Human Rights Act. So this was contemplated in the explanatory notes to the bill, which says that the aim of the bill is to consolidate and establish statutory protections for certain human rights recognised under international law, including those from the ICCPR. Okay, so it's explicitly referring to those international rights. And section 48(3) of the Act says that international law and the judgments of domestic, foreign and international courts and tribunals relevant to a human right may be considered in interpreting a statutory provision. Now, look, this doesn't import foreign case law into Australia, and this is something that has been considered in another context by the courts where it perhaps didn't have as strong an effect as I had perhaps hoped this would, but that international context is still definitely going to colour the way that this Act is interpreted, and I think that's something really important to bear in mind. And the final of my three interlinking points is that there is a very clear link between climate change and human health impacts in Queensland, and therefore impacts on human life. So science tells us that climate change will result in increased global temperatures, which will have an avalanche of associated impacts, including increased heat waves and natural disasters. And there's a wealth of scientific data available, really clearly outlining what the threats are to human life from climate change in Australia and even in Queensland specifically, if climate change continues unabated. And I'm just going to go through these risks very briefly in turn. So heat waves, we know that heat waves are projected to increase in frequency, duration and intensity. And scientific studies have shown links between higher temperatures and greater mortality. There was a study that showed statistically significant increases in Brisbane emergency hospital admissions during heat waves. So there's a very overt impact on life from heat waves, which in turn can cause pressure on health services, which I'm sure we're all acutely aware of at the moment, what can happen when there is pressure on health services. It's got a pretty overt impact on human life. And there was also a study in Brisbane that made a correlation between heat waves and preterm births. And obviously there's a much, I guess, lower risk of survival depending on when a baby's born. So that's an impact on human life as well. Natural disasters, bushfires and cyclone events, amongst others, are projected to increase in frequency and/or intensity under climate change. And there are very clear, direct human health and human life risks from those sorts of events happening. Infectious diseases, climate change is predicted to increase the incidences of some infectious, vector-borne, foodborne, and waterborne diseases. So just as one example of many, climate change will result in larger communities of mosquitoes in Australia, which therefore increases dengue risk, which therefore poses a threat to human lives. There's a lot of literature there. Climate change will impact on water and food security through increased drought as a result of decreased rainfall, which has obviously fairly clear impacts on water security, but also food security, which then in turn has impacts for human life. And finally, mental health impacts from climate change. Climate change is projected to have direct and indirect impacts on mental health. So direct, for example, through trauma related to climate change related disasters. So if you lose your home or you're physically injured as a result of a disaster. And also indirect impacts, so as a product of physical stress or through disruption to community well-being. And there was a study that showed that extreme heat can have a harmful impact on mental health just of its own, extreme heat, with the impact thought to be as detrimental to mental health as periods of unemployment. And in warmer states, including Queensland, there has been observed a positive correlation between mean annual temperatures and suicide rates as well. So there really does seem to be a connection between increased heat events and really negative impacts on mental health, which is obviously a threat to life as well. So what I've shown there through those slides is those three interlocking points to really set the groundwork. So internationally, climate change is linked to the right to life. Number two, the international context is relevant to interpreting the Queensland Human Rights Act. And thirdly, climate change will have human health impacts in Queensland, which is a threat to the right to life. So the next thing that we need to consider is how then we draw these points together in a meaningful way to progress climate change litigation. So circling back to what we talked about before, which was the existing context we've got for climate change litigation. All right, so how the Human Rights Act works, it is a bit of a doozy of an act procedurally, so I'm only going to gloss over some of the fairly complicated points of it. But the Act does several things. I think we can boil it down to several key functions. It aims to embed human rights discourse into public decision-making. It sets up the Office of the Human Rights Commissioner, and complaints can be made and mediated by the Commissioner. And it also allows limited rights of action before a court, which is what we're interested in tonight. But it is important to bear in mind that the main object of the Act is not to create a regime whereby violations of human rights are widely litigated as a first line of action. So instead, it's really aiming to create a culture of human rights, or a dialogue is the language used, in public decision-making with litigation as a last resort. So it really places a burden on decision makers to have human rights in mind when they're making decisions, with the idea that you'll get good decisions being made and you don't need to have them going to court. It includes all sorts of measures such as parliamentary scrutiny of legislation to ensure that it is compatible with human rights, although I'm not going to get to it in detail, but incompatibility is not fatal. And courts are also encouraged to the extent possible and as consistent with their purpose, interpret legislation in a way that's compatible with human rights. So I think it's just important to say at the outset, litigation is not the point of the Act, but there is some machinery in place for litigation. What's important though is that those rights that we looked at before, we underlined the ones in red relevant to climate change. There's no really, I suppose, overt way to just challenge a violation of a human right directly. You need to go through this slightly more circular process. And to understand this, you need to look at these provisions in particular. So Section 58 says it is unlawful for a public entity to act or make a decision in a way that is not compatible with human rights, or in making a decision to fail to give proper consideration to a human right relevant to that decision. Okay, so if a public authority makes a decision that is incompatible with the human right to life, Section 58 says that that is unlawful. Okay, so it's unlawful, but the path to a cause of action for challenging that unlawfulness is a little bit complicated. And this is where Section 59 comes in. So what Section 59 says is effectively, if you have another non-human rights cause of action alleging that a decision is unlawful, then you can bring that, And you can also argue that the decision is unlawful because it is incompatible with human rights. And this is referred to as the piggyback mechanism. It's something that exists in the Victorian legislation, and that's where that term came from. So you can't just bring a human rights claim. You have to have another cause of action effectively for challenging a decision on the basis of being unlawful, and then you piggyback your human rights claim onto that. Interestingly, this is something that's been criticised a bit in Victoria, because you've got litigants then coming up with these fairly harebrained primary causes of action when their real concern is the human rights claim, but they've got to bring this primary one to get in the door of the courts, and the court has to entertain this pretty unlikely claim to get to the substance, which is the human rights claim. So, it has been criticised in Victoria for that particular reason, but it was adopted into Queensland. And one thing that is useful to know, actually, and I'll get back to this in a bit more detail later, is that you do not need to succeed on the primary claim to succeed on the secondary claim. So those people bringing in that slightly harebrained cause of action in Victoria, it's okay if they fail on that, they can still succeed on the human rights claim, but I'll come back to that a bit later. A couple of other provisions that are important to look at because they define some of the key terms that we just looked at. So an act, decision or statutory provision is compatible with human rights if it does not limit a human right or limits the right only to the extent that is reasonable and demonstrably justifiable. Okay, so it can be limited to an extent that it is one of those things, or both of those things. That's then defined in section 13, subsection 2. Well, there's a list of things to consider at any rate. So it says, in determining whether a limit on human rights is reasonable and justifiable, the following factors might be relevant. And it lists those things there, like the nature of the right, the purpose of the limitation, the relationship between the limit and the purpose. Are there any less restrictive and reasonably available ways to achieve the purpose, the importance of preserving the human rights, and a balance between those factors. Okay, so that's going to be something important to consider. All right, so that's the machinery of, as I said, what is a very, very procedurally complicated act to the extent we need to know about it for climate change litigation. So it's by no means a comprehensive overview. What I thought we'd just talk about now briefly, and this is really kind of speculative, is how we would frame a human rights and climate change case then in Queensland. There are an awful lot of potential ways, and I've been involved in some really interesting discussions around this over the past year. And a really obvious way is to continue building on existing case law in Queensland, which is those mining challenges that I mentioned before. So those challenges to the approvals for a large-scale coal mine. There are many more mines currently being proposed and approved in Queensland, so involving generally the opening up of the Galilee Basin. So there certainly are those opportunities there to object to a new coal mine approval and then potentially piggyback the human rights claim onto that challenge. And the right to life is just one of a number of potential arguments that could piggyback, but it's just an example that I've chosen to use here. And as I said before, success under the primary action is not a prerequisite to relief or a remedy for the human rights violation claim. So even though, as I said, I think momentum is building towards having a successful mining objection, it's actually not a prerequisite to success under the human rights claim anyway. So it could still succeed even if the primary claim fails. So what a litigant would need to argue to succeed in a case like this is, I guess, firstly, that a decision to approve a mine will contribute to climate change. And we can do this, and this has happened before. And this is particularly the case because Australia is one of the world's largest coal exporters, and Queensland is one of the biggest coal states. And this could be framed within the same sort of science that has been used in cases that have been decided to date. And the cases that have gone before the Land Court have used some really useful scientific literature that proposes something called the carbon budget. So certainly it used to be the case that 2 degrees was thought of as what we as a globe could tolerate as an average amount of global warming based on pre-industrial temperatures, while still staying within safe levels of climate change. So we could still have a pretty good, pretty comparable quality of life as long as we restricted warming to 2 degrees. 1.5 degrees has now really emerged as a better goal, but we're already over 1 degree of warming post industrial revolution, so it's looking pretty doubtful. That's a slight by the by. What the point is that this carbon budget literature was developed in light of this 2-degree guardrail. And these clever scientists said, right, if we are going to stay within 2 degrees, this is the amount of carbon dioxide that the entire globe can emit to stay under that. So it's like a bank account. You've got this much money in your bank account, and that is all that you can spend. So what the litigants did in some of this Queensland case law is framed these proposed mines within that carbon budget literature and said this one mine in this one state, in this one country, is going to chew up a tangible part of this carbon budget. So, somewhere just under 1%, I think from memory is what those figures were. But when you're looking at a global budget to be spent over 50 years, something taking up almost 1% just in one country is a pretty big deal, I thought. So anyway, that's how the significance of single projects have been proven. And I think the carbon budget literature can continue to be used, particularly if it's updated in light of revised thinking around that 1.5 degree target. And opening the Galilee Basin, if we keep going with opening the Galilee Basin, has the potential to erode a massive proportion of the carbon budget and therefore contribute to climate change. So I think we can prove that in a human rights case. We know from what I said earlier that increased greenhouse gas emissions will impact on human life. I think the science is there to show that. The final part of the argument is that inaction on climate change, or in our case, action that will exacerbate climate change, for example, by approving a coal mine, is incompatible with the right to life. So, look, I think it seems pretty obvious to me that you can pin those things together, but obviously convincing a court of this is going to be much, much more difficult. And I guess I can just circle back to my point before about Chief Justice Preston, that you've got to be willing to go out on a limb to make a decision of this type. It is a regime that allows for a lot of discretion. There's not necessarily a legally right or wrong way to approach interpreting this legislation. So you do need to get a judge that really is willing to take that step. Even if you can convince a court that a decision to approve a coal mine was incompatible with human rights, you've then got the risk that the government entity might establish that the limit was reasonable or demonstrably justifiable. And for example, just doing some thinking here, the government could argue that the nature of the purpose of the limitation justifies it, and that would be on the argument that perhaps coal is important on economic grounds. I would argue against this with international material. So, for example, the Human Rights Committee has observed that the right to life is the supreme right from which no derogation is permitted, even in public emergencies which threaten the life of the nation. Okay, so we just don't mess around with the right to life. And certainly commentators have argued that economic reasons should never override the right. Okay, so not binding on a Queensland court, but some very, very strong statements that I think could potentially meet that claim. The other thing that we thought could perhaps happen is that a government might argue that there were less restrictive and reasonably available ways to achieve the purpose being to protect human life from climate change. And this might include things like encouraging clean energy or adapting to future climate hazards, so putting up seawalls, for example. But as you'll probably remember from my little rant on the market substitution assumption, I'm never a big fan of trading off certainty for uncertainty. And I think certainly that's what that involves. This certain mine that we've got before us is being traded off for something that may or may not happen in the future, which I think is a bit problematic. There are other barriers to consider as well. So I acknowledge in this that our interpretation of the right to life is quite broad, and it does require a judge to really go on a bit of a journey with you to link together some concepts to get the end result. So I'm not I'm not naive to that it is a difficult claim to make. And it therefore does go hand in hand with judicial willingness. And Queensland courts have been quite conservative in the past when it comes to climate change arguments, whereas the successful cases I mentioned overseas have arisen in jurisdictions with strong constitutions and a history of judicial activism. So I think that's something to consider. We also have that complicated chain of causation, which has always been a problem in climate change litigation. So This is what I think you'd need to go through to prove causation, that Queensland government has approved a project. The project will result in increased emissions. These emissions will contribute to climate change. Climate change will have impacts on human life in Queensland. And finally, these impacts are not compatible with the human right to life. And I think the first three shouldn't be too hard because that's the progress that has been made to date in Queensland. The fourth step, I think science really clearly shows that climate change will have impacts on human life in Queensland. I think that's a pretty obvious point on the science. Convincing a court of this fifth step is going to be challenging, and particularly so because there's no jurisprudence in Queensland on human rights at all, and there's nothing nationally dealing with climate change in the human rights space. So it's all going to circle back to the point of judicial willingness, which is something that's relevant, I think, in all climate change litigation. So just some final concluding marks. Climate change litigation is not going anywhere. I think in the absence of strong legislative action on climate change, which we certainly don't have any indication will happen anytime soon, environmental groups will continue, as they have been doing so for quite a long time, to turn to the courts to seek relief. Climate change litigation is a long game, so it might take many cases to get a successful result, but that successful result will be built on many, many incremental steps. New avenues for legal challenge are continually being explored, and lawyers in this space need to be really nimble. And I never thought I'd be spending so much time looking at human rights as a domestic environmental lawyer, but I really think it is one of the biggest avenues for potential climate change action going forward, as well as potentially corporate law, which I don't want to touch. Human rights is a bit more palatable. Queensland's Human Rights Act presents enormous opportunities for climate change litigation and action more broadly. And I think one really interesting thing, we were talking about this before the talk started, is I feel somewhat confident that this is a piece of legislation that will survive changes of government as well, because you don't want to be the government that repeals human rights. So I would like to hope that it is something that is going to endure for some time. And I think tonight's talk has really just scratched the surface of one possible avenue for dealing with climate change under the Act. So I think watch this space in coming years. It's potentially going to be a really exciting area. All right, so thank you very much. I've probably gone a bit over time there. Sorry, Nick, but yeah, encourage questions.